Graphology is the supposed practice of analyzing someone's handwriting to figure out their character, personality, or how they're feeling. While it was kind of popular for things like hiring people or criminology, today it's facing a lot of scrutiny. Many experts compare it to fortune telling, and lots of studies question whether it's really scientific. Even so, in countries like Mexico, graphology has even been used in court cases, causing ethical and legal problems. Coming up next, we'll take a close look at the graphology from different angles. Di ko kita scientific, legal, ethical, social, financial, and emotional, focusing especially on how things are in Mexico and the United States, as well as mentioning Europe and South America.
From a scientific perspective, graphology lacks a solid empirical foundation. The central premise that handwriting is a reflection of the soul has not passed rigorous testing. In fact, the British Psychological Society rates it on the same level as astrology, giving both zero validity. Numerous studies have tried to connect personality traits with handwriting characteristics, without success. For example, a meta-analysis of 200 studies concluded that graphologists clearly failed to show validity or reliability in predicting job performance, skills, or personality. No graphology school got better results than any other, and they didn't even do better than untrained people making random guesses. In most studies, neither graphologists nor regular people guessed correctly more than what would happen by chance.
An experimental study done in Italy showed these weaknesses. 101 students took a Big 5 personality test and also provided a handwritten text for graphological analysis. The evaluations of 2 graphologists did not match the actual personality traits, and the graphologists didn't even agree with each other in their diagnosis. In a second phase with another 102 subjects, including people with no graphology training as a control group, there was no evidence that graphology can accurately measure personality. Consistently, modern research rejects graphology as a tool for evaluating personality or job performance. It is considered a pseudoscience today.
In Spain, the Ministry of Science itself does not recognize it as an official scientific field, technically placing it in the category of pseudoscience. This is pointed out in a report by the British Psychological Society. We have not found evidence to support the use of graphology, and the findings tend to be negative. Researchers emphasize that many correct guesses attributed to this practice can be explained by psychological phenomena like the Barnum effect, vague descriptions that anyone can relate to personally, and other cognitive biases. In conclusion, from a scientific point of view, there is no evidence that handwriting reliably reveals deep personality traits. Its former prestige has been widely discredited. The supposed laws of graphology do not hold up under controlled testing, and the seemingly reasonable idea that handwriting is brainwriting is as unscientific as other fortune-telling methods when examined rigorously.
In Mexico, graphology has found a legal loophole that allows it to be used in court proceedings as expert testimony, even though it's not recognized as a science. There isn't a federal law that specifically forbids its use in court, so it's up to the judges to decide whether or not to accept these opinions. This has led to some controversial situations. Recently, it was revealed that the Superior Court of Justice of Mexico City is accepting graphology reports submitted by aggressors against mothers in order to take away their custody rights. In other words, a mother's handwriting has been analyzed by a graphology expert and used as an argument to consider that her personality would make her incapable of caring for her children. A very serious and potentially biased use. Activists and legal experts say this practice violates fundamental rights, because graphology lacks scientific reliability to support such conclusions.
The lack of specific regulation has led to graphology experts offering their services in civil and criminal trials. For example, in cases of sexual abuse or custody disputes, presenting personality reports. Some local courts have admitted them as evidence, although always along with other evidence and at the judge's discretion. This has prompted a reaction from civil society. At the end of 2024, after the well-known legal confrontation between the media graphologist Marifer Centeno and the YouTuber Mr.Dr, who accused her of quackery, a group of activists promoted an initiative informally known as the Anti-Marifer Centeno Law to eliminate graphology as expert evidence in the judicial branch. This class action lawsuit seeks to set a precedent that graphology reports are not admitted given their lack of reliability and scientific basis.
In an interview, promoter Diana Luz Vasquez urged the judicial branch to stop considering graphology in proceedings where women are seeking justice for violence or disputing custody to avoid re-victimizing them. In short, Mexico is experiencing a moment of legal reflection. From a permissiveness by omission, there is a shift to public questioning of graphology in courts with a view to restricting or prohibiting its evidentiary value. In the United States, graphology has a much more skeptical and limited legal reception. The U.S. legal system has strict standards for admitting expert evidence, like the Dober or Frye standard depending on the jurisdiction, that require evidence to have general scientific acceptance or reliable methodology. Graphology doesn't meet these requirements, so it's rarely, if ever, admitted in trials to prove someone's personality or truthfulness. In fact, forensic experts call it junk science and emphasize its subjective nature.
It's important to distinguish that forensic handwriting analysis, called questioned document examination, admissible in the U.S. to verify the authenticity of signatures or determine the authorship of a document, which is a different discipline. Forensic handwriting experts routinely testify about whether or not the defendant wrote a certain note, for example. However, that analysis focuses on comparing the physical traits of the handwriting, not on inferring psychological traits. Graphology as a personality assessment, on the other hand, is not recognized in U.S. courts.
A study published in the International Journal of Forensic Document Examiners emphasized that there's no consistent correlation between handwriting and personality, concluding that allowing graphologists, trained only in that art, to testify as experts lacks support and would be foolish from a scientific perspective. In other words, serious courts don't believe a graphologist has a valid technical basis to offer expert opinions about someone's behavior or character.
In the workplace, the use of graphology has also been legally questioned. An opinion letter from the EEOC, Equal Employment Opportunity Commission, in 2001 warned that using graphological analysis in hiring can clash with anti-discrimination laws. For example, asking a candidate's age or medication to adjust the reading of their handwriting is illegal under the Americans with Disabilities Act, ADA, and could be evidence of age discrimination. Although there is no explicit ban on consulting graphology in personnel selection, these warnings and the lack of scientific backing have made its use marginal in the United States, and if it's done, it's kept very private to avoid legal challenges. In short, the U.S. legal system doesn't consider graphology reliable. Courts exclude it because it's not generally accepted by the scientific community and doesn't demonstrate consistent reliability, equating it more to fortune-telling than forensic science.
In Western Europe, handwriting analysis doesn't have legal backing in serious criminal cases, though its use changes depending on the country and situation. In Spain, for example, handwriting analysis isn't officially recognized as science. It's not in formal academic areas and is considered pseudoscience. However, Spanish legal rules allow practically anyone with special knowledge to act as an expert witness, whether or not they have a formal title. This means that, in theory, a handwriting analyst could present a report if the judge allows it.
In fact, there's no specific law against it. The civil and criminal procedure laws state that it's up to the court to decide if expert evidence is allowed and how important it is. In practice, it's the judge's call whether to accept a handwriting analysis. Some Spanish judges have allowed handwriting reports as extra information along with regular psychological reports, especially in unusual cases, while others completely reject them.
Here's an example from Spain. In 2021, a court in Valencia agreed to include a handwriting analysis report in the Godella double homicide trial. This caused debate, since handwriting analysis isn't seen as scientifically reliable, and it was included because the judge decided to. The General Council of the Judiciary in Spain confirmed there's no official rule about using it, leaving it up to each judge. However, when it is allowed, it's usually required to be used with regular psychological reports, and it's never the only deciding factor. So, in Spain, it's not forbidden, but it's viewed with suspicion and isn't seen as strong evidence.
In other European countries, the trend is similar. In the United Kingdom, because psychologists are skeptical, handwriting analysis is almost never used in court. They prefer evaluations by certified forensic psychologists. In France and Italy, while handwriting analysis was more common in the past, it's rarely used legally today. France uses it more in hiring than in courts. And in Italy, its use in court decreased as scientific psychology grew. Interestingly, in Hungary, there's even a privacy issue. A report from the Data Protection Commissioner said that analyzing someone's handwriting without their permission violates their privacy. This suggests that making someone do a handwriting analysis could break fundamental rights in some European countries.
To sum up, in continental Europe, handwriting analysis isn't trusted as legal evidence except in rare cases. Most people think it's not technically reliable, even though the law doesn't always forbid it directly. This leaves gaps where it depends on what each judge decides.
In South America, the situation is a mix of European continental influence and the varying use of handwriting analysis in workplaces and police work. Many countries in the region allow non-traditional experts in court, which opens the door for handwriting analysts to offer forensic services. But there are also legal precedents that disqualify handwriting analysis in favor of scientific disciplines.
A strong example comes from Colombia. In 2014, the fourth section of the Council of State warned that handwriting analysis cannot establish the authenticity, forgery, or alteration of a document, nor the identity of its authors. They pointed out that the ideal method for these purposes is expert analysis in graphology or documentology.
In other words, the highest administrative court in Colombia established that to determine if someone signed a paper or if a writing is fake, handwriting analysis is not enough. A specialized technical study is required. This draws a clear dividing line between handwriting analysis and true forensic document examination, pushing aside the former for lack of rigor. As for the use of handwriting analysis for personality profiling in South American court cases, the information is usually anecdotal. In general, it is not formally accepted as expert evidence in legal codes in the region. However, it is possible to find isolated cases where a judge has admitted reports from handwriting analysts by analogy with psychological assessments.
Countries like Argentina or Chile traditionally use handwriting experts for the authenticity of writings, but personality-based handwriting analysis is not part of official forensic protocols. Even so, given the flexibility in the role of the expert witness, it could be presented in civil disputes such as inheritance trials to assess the clarity of mind of a testator through their handwriting, but it would face serious opposition in higher courts.
Similar to Mexico, these nations do not have explicit anti-handwriting analysis laws, relying instead on the sound judgment of the judge and the challenge that the opposing party can make if they consider it to be junk science. In short, South America reflects both the theoretical possibility that handwriting analysis could sneak into courts due to legal loopholes, as well as a growing judicial awareness that its contributions are neither reliable nor scientific, favoring orthodox psychological expert opinions and verifiable technical evidence. Over the years, there have been cases in different countries that show the questionable use of graphology in legal situations. These examples show the results, sometimes serious ones, of giving importance to an unscientific practice in legal decisions. The Godella case in Spain in 2019 sparked debate across Europe. In the trial for the murder of 2 children in Godella, the Guardia Civil presented a handwriting analysis report that created psychological profiles of the parents based on samples of their writing. According to news reports, the official handwriting expert described the father as having an unstable temper and a tendency to deceive, while he portrayed the mother as spontaneous and sincere. This description, based only on their handwriting, immediately drew criticism from experts and people on social media, who called graphology a pseudoscience, fortune-telling, and a scam. Even though the court convicted the couple of the double infanticide, it was made clear that the sentence was based on a wider set of evidence and not just on the questionable handwriting analysis report. However, the simple fact that the report was allowed and became part of the case file created serious public doubt. Is it okay for a defendant's personality to be shown using a method similar to palm reading? This case highlighted the training of experts and the ability of judges to tell the difference between scientific and unscientific evidence. Graphology reports in custody cases in Mexico between 2018 and 2024 have also brought several alarming cases to light where graphology played a role in child custody decisions and other family court proceedings. Activists have documented situations where women reporting violence or requesting child support were harmed by graphology reports presented by the other side. In these reports, a hired graphologist would evaluate the mother's or father's handwriting and draw conclusions about their supposed instability, honesty, aggressiveness, etc., which were then used in court. Diana Luz Vasquez, leader of the campaign against forensic graphology, collected testimonies from several affected women who are part of the Ley Sabina collective. they all describe how they were given a personality evaluation based on their handwriting and how this was used to try to take away their custody rights or discredit them in domestic violence cases. In the activists' words, this is a re-victimization of female victims by introducing a pseudoscientific element that casts doubt on their credibility or maternal aptitude. These cases don't always make the news with names attached, but there have been enough of them to spark a reform movement. The consequences have been very serious in some cases. Mothers temporarily separated from their children or drawn out legal processes because of evidence that was later shown to be invalid. Public pressure and outrage from legal experts have led federal judges to speak out unofficially against allowing these kinds of expert reports in the future. However, until there is a change in the law, the risk of similar cases remains, with the resulting harm to the families involved. Other controversial uses of graphology have been documented. In the mid-20th century in the United States, some criminologists tried to profile criminals through their handwriting, such as examining the Zodiac killer's letters in the 1960s to infer psychological traits of the author. These efforts never produced conclusive results and were never accepted in court, but they show the almost mystical appeal of the idea. In France, it was documented that in the 1980s and 1990s, some labor judges considered graphology reports in labor disputes or in guardian suitability assessments, something that was later abandoned after being heavily criticized by psychologists. And in Argentina, although graphology has been more common in private settings, there was controversy when, in a well-known police case, an investigator claimed to have profiled the suspect through their handwriting. In the end, this had no evidentiary value, and the case was solved using traditional physical evidence. These examples show a pattern. Wherever graphology has been used to accuse or exonerate, it has generated controversy. If it contributed to a conviction, there are fears that the conviction is unjust because it's based on a questionable method. If it contributed to an acquittal, there are fears that a guilty person escaped justice because of reliance on an unsupported analysis. In many of the recent controversial cases, the result has been a call for caution or a ban judges correcting themselves in higher courts, justice committees reviewing protocols for admitting expert reports, and even ongoing legislative reforms. Thus, each case has set precedents for what should not be done in terms of evidence. Graphology shares many similarities with other pseudosciences like astrology, palm reading, or phrenology. Just like these practices, it claims to uncover hidden aspects of a person through subjective interpretations, and it lacks a verifiable experimental basis. In fact, the scientific community explicitly equates graphology with astrology in terms of its lack of validity. Both score 0 when evaluated for their ability to predict or explain anything. In practice, graphology opera much like astrology external signs such as the shape of letters or the pressure of the stroke, and assigns predetermined meanings about personality to them. These interpretations are usually vague or general enough that many people feel they apply to them, giving them an illusion of accuracy. Like other pseudosciences, graphology tries to present itself with the appearance of science. It uses its own technical language, classifies types of handwriting, offers courses and certifications, and even cites historical figures pretending to have a scientific lineage. However, this doesn't prevent it from failing under objective scrutiny. Just like iridology, palmistry, or phrenology, which also had schools and followers at one time, but were experimentally refuted. A skeptic pointed out that all these techniques require years of training, promise to reveal hidden truths, and some even issue expensive diplomas, but none pass double-blind tests or meet minimum criteria for reliability. In the particular case of graphology, its defenders use the motto, "Handwriting is the reflection of the brain," arguing that neuromuscular traits are reflected on paper. However, this idea sounds scientific but isn't. There's no consistent mapping between graphological traits and specific brain circuits or psychological characteristics. It's like saying that the position of the stars influences personality, a statement that's appealing because of its cosmic simplicity, but without a verifiable mechanism. Another parallel with astrology is that graphology tends to survive in popular culture despite the evidence against it. Many people continue to read horoscopes just in case or for entertainment. Similarly, there are plenty of magazines, websites, and experts offering graphological analysis, taking advantage of the human fascination with learning about themselves. Both practices benefit from subjective validation. When they get something right, the client is impressed. When they fail, the mistake is usually forgotten or rationalized. Also, just as there are people who make important decisions based on their astrological chart, there are companies or individuals who make decisions based on graphology, which creates similar risks of systematic error. In short, graphology belongs to the same group of pseudo-scientific disciplines as astrology, numerology, or tarot reading. They all share a lack of empirical support, the use of non-standardized interpretive techniques, and a presentation that may seem scientific but doesn't hold up under rigorous analysis. While each pseudoscience has its own particular flavor, deep down they operate on principles similar to those of traditional divination arts. It's telling that skeptics place graphology alongside astrology, palm reading, and other divination arts in their lists of unsupported practices. The conclusion is clear, however appealing or logical its basis may sound. Graphology is no different from other pseudosciences in its lack of objective validity. Using handwriting analysis for decisions that affect people's lives, freedom or rights raises serious ethical questions. One of the pillars of justice is to rely on solid proof and trustworthy expert opinions. Bringing in a technique that isn't scientific could violate the right to due process and a fair trial.
From a judicial ethics perspective, allowing handwriting analysis to influence a verdict is problematic because it misleads people about its actual reliability. A judge has the responsibility to filter out what lacks rigor, and by not doing so, they would be failing to be objective. In Mexico, for example, the ethics of judges who accepted graphology reports against mothers in custody cases has been questioned. People argue that something is preventing judges from understanding that handwriting analysis is considered pseudoscience due to lack of evidence. By putting supposed proof above scientific standards, those judges would have acted carelessly, bordering on indifference to factual truth.
There is also an ethical duty not to harm others with invalid testimony. A handwriting expert who presents their conclusions with the same seriousness as a medical examiner is, intentionally or not, misleading people. The affected party, whether defendant, victim, or anyone involved, suffers an injustice if that opinion is taken seriously. For example, convicting someone based on a handwriting profile would be ethically unacceptable, just as it would be to acquit a guilty person because their handwriting shows sincerity. These are extreme hypothetical cases, but they highlight the principle. Using non-scientific evidence can lead to judicial errors that violate the ethical principles of truth and justice.
Privacy and consent considerations also arise. Having someone provide a writing sample for psychological analysis without warning them about the lack of support for the technique is ethically questionable. In some jurisdictions, it is equivalent to a violation of privacy or dignity. For example, in Hungary, where an official report criticized graphological analysis without explicit consent, considering it invasive.
On the other hand, in the workplace or education, subjecting candidates to handwriting tests can imply hidden discrimination. The person being evaluated doesn't know the criteria and could be rejected based on an arbitrary judgment, such as their handwriting revealing aggressiveness, which clashes with the ethics of equal opportunity. In fact, the US EOK suggested that basing hiring on graphology could be a pretext for discriminatory practices, violating professional and legal ethics. In short, the ethical dimension forces us to ask, is it right to allow an unsupported test to influence people's lives? Most specialists agree that it is not. They have compared accepting graphology in court to accepting the opinions of a shaman or a psychic, an ethically unacceptable situation in a modern state governed by law. Therefore, many advocate for judicial codes of ethics that explicitly prohibit the use of pseudoscientific tools and for sanctions against experts who endorse unvalidated methods, since the integrity of the judicial system and public trust in it are at stake.